Hundreds of youths on Wednesday evening took to the streets of Kano, protesting over the appeal court judgments that sacked Abba Yusuf as the governor of the state. The protesters, comprising workmen, set tires on fire along the Dan Agudi area of Kano while chanting a solidarity song for the governor, but they were dispersed by police officers who mobilized to the scene of the protest. Policemen barricaded the road leading to the government house, while motorists were diverted to drive on one lane. The protesters were seen in the Kofa, Nasarawa and BUK road. The fresh protest came after the certified true copy CTC of the judgment surfaced in the public domain and seemed contrary to the verdict of the appellate court. Some of the protesters said they were ready to die as they demanded justice.
This morning, the concerned citizens of Kano arranged a peaceful prayer session in the Mahaha field. Unfortunately, after the peaceful session, the Nigerian police come and open fire on us. This is open day robbery. The Kano mandate has been stolen by the APC. The APC are trying to turn the Nigerian political system into one-party system. This will never be accepted, and we are calling on the masses to start bringing us food, water and other supplies. We will not leave this place. We are going to die here. We are going to sleep here. We will not move. We will keep staying here until the justice prevails. Our appeal has been already submitted to the Supreme Court, and these people are calling numerously on the issues to defend APC. APC is a fraud. APC is a one-party system. We are here to die for Abba. Abba is the governor we elected. We are here to die. It's either police to kill us or go and kill Ganduje. Ganduje is the culprit behind all this, what is happening in Kano. Enough is enough. We cannot continue this way. Enough is enough.
Da ai namu ne kayan.
Amma gwamnati ta mu ce.
Shine ai nace namu ne kayan.
Yawa kayan namu ne.
On November 17th, the Court of Appeal in Abuja affirmed the verdict of Kano State Governorship Election Petition Tribunal that removed Yusuf. The tribunal had sacked Yusuf, the candidate of the New Nigeria People's Party, Nnpp, as governor of the state. The three-member panel of the appellate court held that the Nnpp breached the constitution by sponsoring Yusuf, who was not a member of the party when the election was held. The court held that Yusuf's name was not in any of the membership registers of the Nnpp tendered before the tribunal, a contravention of Section 177C of the 1999 Constitution. Meanwhile, the New Nigeria People's Party has filed its notice of appeal before the Supreme Court to challenge the November 17th judgment of the Court of Appeal, which upheld the decision of the Election Petition Tribunal sacking Governor Abba Yusuf and declared Dr. Nasiru Gawuna of the All Progressives Congress (APC) as duly elected governor of the Kano State. In a notice of appeal dated November 22nd and filed by Senior Advocate of Nigeria, Boyega Awomola, leading 7 other senior advocates and 10 other lawyers, the Nnpp listed 10 grounds for challenging the appeal. The party challenged the entire judgment of the Court of Appeal except the conclusion and orders at page 67 of the duly certified true copy, including the order as to cost favorable to the appellant. Listed as respondents in the notice of appeal are Governor Abba Yusuf, the APC, and the Independent National Electoral Commission (INEC). On November 17th, the Court of Appeal upheld the decision of the Election Petition Tribunal, which sacked Governor Abba Yusuf of the New Nigeria People's Party and declared the APC candidate Dr. Nasiru Gawuna winner. The three-member panel of the appeal court dismissed the appeal filed by Governor Yusuf based on his membership status in his party. Confusion, however, ensued on Tuesday, November 21st, when the CTC of the court judgment, which surfaced 4 days after the judgment had been delivered, showed contradictions in the conclusions. In the lead judgment delivered by Justice Moore Adumayan, the judge held in one of the concluding paragraphs on page 68, quote, "I will conclude by stating that the live issues in this appeal are hereby resolved in favor of the first respondent and against the appellant. The judge went further to hold that in the circumstances, I resolve all the issues in favor of the appellant and against the first respondent. Therefore, I find no merit in this appeal, which is liable to be and is hereby dismissed. The judgment of the Erupts in petition number EPT KN GOV 01-2023 between All Progressives Congress APC versus Independent National Electoral Commission INEC and two others, delivered on 20th day of September 2023, is hereby set aside. The sum of 1 million naira is hereby awarded as cost in favor of the appellant and against the first respondent. While the last three conclusions of the judge suggested that the tribunal judgment sacking Governor Yusuf had been set aside and restored his mandate, the first conclusion that resolved the issues in favor of APC suggested that the decision of the tribunal was affirmed. In its grounds of appeal, challenging portions of the judgment, the Nnpp said the learned justices of the Court of Appeal erred in law and occasioned a grave miscarriage of justice to the prejudice of the appellant when it agreed with the trial tribunal that the party candidate was not qualified to contest the election because he was not a member of a political party. The Nnpp noted that the Courts of Appeal reviewed and reversed the tribunal's judgment, which went in favor of appellants and first respondent on the issue of party membership when no ground of appeal or issue was formulated to warrant such a review. The Nnpp also argued that the Court of Appeal erred in law and came to a perverse decision when their lordship mixed up the issue of party membership register for use at party primaries with qualification to contest the general election. The party also submitted that the justices of the Court of Appeal misdirected themselves in law by misapprehending the issue in the appeal when they delved into alternative hypothetical scenario and became a cross-appellant with a grievance against the decision of the tribunal and reversed same on the issue of disqualification, thus granting prayer not sought in the appeal. Now, the learned justices of the Court of Appeal erred in law, acted without jurisdiction, and breached the appellant's right to fair hearing, thus coming to a wrong conclusion on the actual issue submitted for their resolution regarding the trial tribunal's assumption of the role of petitioners by reviewing documents dumped on the court in the tribunal justices' chambers, whereof the tribunal arbitrarily discovered, isolated, and deducted 165,000 votes from the total votes of 1,019,602 and recounted the remainder of votes cast for appellant and its candidates first responded to conclude that all Progressive Congress candidates who scored 890,705 votes at the election had more votes and ought to have been returned as the winner of the governorship election held in Kano State on March 18th. That the court below erred in law when it held that the appellant's candidate was not a member of Nnpp, the political party that sponsored him for governorship election in Kano State, and therefore not qualified to contest the said election. That the court below erred in law when it held that appellant's candidates shouldn't have personally given evidence to establish his membership of his party, and that such failure to testify is fatal to his case. That the court below erred in law when it upheld the decision of the tribunal nullifying the election of the appellant's candidate as elected governor of Kano State and declaring first respondent's candidate as the winner instead. That the learned justices of the Court of Appeal erred in law and occasioned a grave miscarriage of justice when they held that the live issues in this appeal are hereby resolved in favor of the respondent and against the appellant when the issue of the constitutionality of the judgment of the election tribunal delivered in violation of the mandatory provisions of the Constitution of the Federal Republic of Nigeria 1999 as amended was not properly considered. That the learned justices of the Court of Appeal erred in law when they held, if, as rightly found by the tribunal that the appellant Yusuf Kabir Abba was not a member of the first respondent, New Nigeria People's Party. At the time, he was purportedly sponsored for the governorship election held on March 18, 2023. Then, he was not qualified to contest the election by Section 17C of the Constitution of the Federal Republic of Court of Appeal, setting aside the judgment of the trial tribunal in petition number EPTRV GOV 11/2023 and making order as to costs in favor of appellant. Such further orders as this honorable court may deem appropriate in the circumstances of the appeal.